The case that we will be focusing on today is Australian Conservation Foundation Incorporated and Minister for the Environment.
This is a recent case heard by the Federal Circuit Court of Australia in 2016. It is the latest in a long line of legal challenges involving large-scale resource projects in the Queensland region based on climate change grounds.
In this video, we will analyse the case and explain its significance in the realm of administrative law in Australia. In October 2015, the former Federal Minister for the Environment approved the Adani Carmichael coal mine under the Environment Protection and Biodiversity Conservation Act 1999. Let's shorten this to the EPBC Act.
ACF sought judicial review of the Minister's decision to approve the mine. Judicial review is a legal process where a court examines the legality of an administrative decision. Basically, the judge is only allowed to look at whether the decision maker in the first instance made an error of law in the way they decided the case. They can't look at the facts again.
In this case, the court emphasised at the outset that the court cannot step into the shoes of the minister and decide for itself whether Adani's actions should be approved. The court can only review the legality of the minister's decision, not its merits.
ACF argued that the minister failed in his duty to consider the mine's impact on the Great Barrier Reef. Adani coal mine is to become one of the world's largest open-cut and underground coal mines. ACF opposed the mine primarily because they were concerned about the impacts of greenhouse gas emissions arising from the transport and combustion of coal.
A shipping terminal located opposite the Great Barrier Reef would export the coal to India, and ACF said that this would increase the risk of collisions, spills, and excessive coal dust that could harm the coral. ACF alleged that the minister failed to comply with the requirements of the EPBC Act.
ACF argued 3 grounds of appeal. The court rejected all of them. Firstly, the minister made an error of law in failing to apply Section 137 of the EPBC Act, which is a prohibition on acting inconsistently with Australia's obligations under the World Heritage Convention. ACF said that the minister failed to consider the effect of the combustion emissions on the Great Barrier Reef World Heritage Area, as he did not mention it in his statement of reasons. In rejecting this ground, the court found that this does not mean the minister did not turn his mind to this.
Secondly, the minister made an error of law by not characterising the impact of the transport and combustion emissions on the reef as a direct consequence of the mine in accordance with the EPBC Act. The court rejected this argument, saying that the minister had explained why he could not make that finding of fact, and the court reiterated its limited role in reviewing findings of fact. Thirdly, the minister made an error of law in failing to consider or apply the precautionary principle, as he was required to do so under the EPBC Act. The court found that the absence of any explicit reference of the precautionary principle in the minister's statement of reasons does not mean that his decision is invalid.
This case has significant implications for the future of administrative law, especially the accountability of executive decisions in the face of potentially catastrophic climate change. While it was undisputed that global warming is the biggest threat to the Great Barrier Reef, because there was technically no error of law, the appeal could not succeed. The case came down to a very narrow legal point, the definition of impact under the EPBC Act.
In addition to highlighting weaknesses in our administrative law's accountability mechanisms, the case also demonstrates that the government will have little difficulty in tightening up policy and law so as to diminish the interference of the courts. While ultimately unsuccessful, the government immediately attempted to repeal the provision in the EPBC Act that gives environmental organisations legal standing to object to projects on legal grounds.
Here at Locus Standi Lawyers, we believe the court made the correct legal decision. ACF had the required standing to bring their appeal, but the court could not interfere with the powers Parliament conferred on the minister. The court acted in accordance with the powers conferred to it under statute and the principles of administrative law.
Administrative law is public law. That is, it's about members of society holding governments and public agencies to account to ensure that their decisions are lawful. When cases such as this have such wide public interest attached to them, it's easy to see why the outcome can be disheartening. ACF believed they could hold the minister to account because of the immense environmental impacts proven to occur if the mine went ahead. Unfortunately, there is not always a legally viable avenue in which to do so.
It is clear that political willpower and influence can restrict access to judicial review of executive power. The latitude given to the minister to assess certain environmental impacts and make findings of fact, which are then essentially untouchable by judicial review, means that even decisions that can have a devastating global impact are immune from challenge.